don't know. I could ask, you know, for sure. Trying to stay at the house and all that. Mm-hmm. Right. I wonder about Pat, Mel's wife. Mm-hmm. No, she retired from the city a couple years back. Mm-hmm. I believe she keeps her license up. But, you know, I can check too and see. I mean, I know what you mean. It's not like it's just a formality.
It's giving me a hard time today. Oh, you know why I had no sign? Just go.
I'm Chris Burrell, president of the Magic City Bar Association. Thank you so much for joining our social distancing CLE series. We've got great information brought to you by great judges and attorneys, and we know that you'll get a lot out of it. The month of August has so many things that we need to acknowledge. From the 100th anniversary of women's suffrage and how that intersects with the right of every American to vote, to the historic nomination of Kamala Harris as Vice President of the United States. There are so many things for us to acknowledge. But we must also acknowledge that August is Black Women's Equal Pay Month. That's the point in the year that a Black woman has to work in order to make the same amount of money as her white male counterparts. What better way to show the absurdity in that disparity than to have the awesome presenters that we have here today. After today's CLE, we need 3 things from you. 1, use the link in the registration email to submit feedback and attest that you attended the CLE virtually. That way, you'll get credit with the State Bar. 2, if you're not already a member, go to www.magiccityBarAssociation.org and join today. 3, go to Facebook, like our Facebook page, and share it with your friends. Thanks for being here. Have a great day, and we'll now turn it over to our CLE presenters.
You're on mute, Judge.
Thank you. Of course I would do that. Good afternoon to everybody. We're really excited to be here and very appreciative of you guys coming on for the CLE. Holly Clemente and Tiara Hudson, we will be speaking with you concerning criminal cases in state and municipal courts, and it is a practical and candid discussion. And we will leave some time for questions at the end. And each of us we will introduce ourselves before our presentation. And so I will give you my view from the bench. And as I said, I am maybe I didn't say, I am a circuit court judge in Jefferson County in the criminal division. And I just have a few things that I would love to share with you guys when it comes to practicing in the criminal courthouse, whether that be in district or circuit court. And the first thing I want to explain is how a case travels. All right. Many people don't quite understand how a case travels through the system. So I'm going to, in a nutshell, give you just a quick overview of how a case travels. And I'll go through this quickly so that I won't take up too much of the time for the other presenters. A defendant is first arrested. Once the defendant is arrested, then a court date is set for what we call a first appearance in district court. All cases in the criminal division, well, for the most part, they mostly start out in district court unless the DA just goes ahead and will indict a defendant. But if a defendant is arrested, he will more than likely have a court date in district court first, and that is set for a first appearance. On that first appearance, nothing really happens there. The court ascertains whether the defendant is indigent and whether counsel needs to be appointed, or if the defendant will hire an attorney. So hopefully by that next court appearance, which is usually called the appearance docket, that's when negotiations start to take place in the district court. My background, I'm a former prosecutor before taking the bench, and I prosecuted with the Jefferson County DA's office for about 5.5 years before taking the bench. I started out in district court as a district judge for 10 years, and the last couple of years I've been in the circuit court. Well, in district court, and I say that just to tell you my experience, in district court, that's the first set of negotiations, and the lawyers and the prosecutor and the defense attorney should be working together to try to resolve as many cases as possible in district courts. The prosecutors should be giving their best offers, and the defense attorneys should be talking to their clients about a swift resolution of the matter if the client is in fact interested in pleading guilty. If the client pleads guilty in district court, then the district court judge will either sentence the defendant or place him on community corrections in some way, but the district court judge would then have supervision of that defendant. If the defendant is not interested in pleading guilty in district court, then the case is waived, what we call waived to the grand jury. Either a case is, if a defendant does not resolve a case in district court, it is either waived to the grand jury, or the judge will make a finding of probable cause after a preliminary hearing. If a case is set for a preliminary hearing, if the judge finds that probable cause exists, that the case be bound over to circuit court to await the action of the grand jury, then those are two ways in which a case gets to circuit court. Now, after a judge makes a finding of probable cause at a preliminary hearing, and there are several cases in district court that will never be set for a preliminary hearing. Lots of them are set for prelims, and there are lots of them where the attorneys and the defendants, they just waive that hearing and they go ahead and let the case go to the grand jury. And Rule 12 of the Alabama Rules of Criminal Procedure controls for the grand jury. A lot of new attorneys are unaware of grand jury and how it works. There are typically, I believe, 18 grand jurors who sit, and 12 of them have to vote to what we call true bill, to indict a case. It has to be at least 12 of them voting to indict a case. When it comes to who is present at a grand jury, that is a very small amount, and you will often hear defendants or defense attorneys make a joke by saying the grand jury will indict a ham sandwich, and that is because nobody is typically present except the district attorney and the witness that the district attorney is calling for the grand jury, and the grand jurors. The defendant is never present, hardly ever present at the grand jury unless there are exceptional circumstances. He's surely not the defendant at the time. Witnesses are sometimes called who could later be charged, but a defendant is never present at the grand jury proceedings. Defendants never get an opportunity to put on evidence at a grand jury proceeding. But Rule 12 really talks about the grand jury. All right. And now I'll tell you a little bit the differences between district and circuit court. So that's really how a case travels from arrest to either district court. Oh, and one thing I will tell you before I get to that is that once the case is in circuit court, that's when we're talking about trial of the matter. We have currently 3 district judges in Jefferson County in the criminal division, and 7 current circuit judges. And in November, we should have 8 current circuit judges sitting in the criminal division. District court judges conduct preliminary hearings on felonies. They conduct bench trials on misdemeanors. take felony pleas, youthful offender pleas. The thing that you do want to remember about district court is that even if a district judge dismisses a case for lack of probable cause or dismisses a case for any matter, the DA can still place that case on the grand jury and indict the defendant for it. And so lots of times when I was a district court judge, if I did not find probable cause after a preliminary hearing for whatever reason, the defendant would get very happy and they would be like, you know, wow, my case is dismissed. And I would always tell them, don't get too happy. The DA can always come back and indict a case, even if a district judge dismisses it. In circuit court, as I've said, that's where your jury trials are taking place. Once the case is indicted, it is then assigned to circuit court. The first setting in circuit court is usually a pretrial setting, and ideally, that is the setting where you want negotiations to take place again. There are several opportunities in the criminal justice system to try to settle a case before a jury trial is had. So this is another time at pretrial. I personally like for pretrial settings to be taken seriously by both sides, both the defense attorneys and the prosecutor. I want my pretrial settings to really be meaningful, where negotiations are taking place, because really I would like for the next setting to be a trial setting, because it's really important to try to have jury trials, to me, as quickly as possible, because if defendants are in jail, you want their cases adjudicated as quickly as possible. Again, at a pretrial, your best offers should be made. And I will say this, defense attorneys, file your discovery motions before pretrial. Once that case is indicted and it comes off of the grand jury, go ahead and file your discovery motion, because at pretrial, you want to have already looked at the discovery so as to try to talk to the DA about a real offer. The prosecutors in the case should have already talked to the victims about resolution of the matter. Pretrials are very important settings, and Rule 16 covers your discovery. If you file your discovery, you should, by the rule, get it within 14 days. Now, there are times in which I think both parties have to work together with each other, but it is incumbent upon the state of Alabama, the prosecutor, to get the discovery to the defendant ahead of time, and enough time for preparation for trial. I think we can all agree that it is unfair to hand discovery over on the day of trial, or sometimes even the week of trial, because the defendant will need to do his or her own type of investigation on it. Also, in circuit court is when you will file your motions for mental evaluation. Lots of times attorneys will try to file those in district court. They are not proper for district court. They must be filed in circuit court after indictment. After a defendant is indicted in circuit court, that's when you can file a motion for a mental evaluation. Another motion that should be filed in circuit court are your motions to suppress evidence. They are not proper for district court. In district court, there are lots of times I wanted to really hear the suppression issue so that we can go ahead and resolve it, but it is not proper. Circuit court is where you file your motions to suppress. So, and go ahead and get all of that taken care of at the pretrial or directly after the pretrial. Go ahead and file your motions to suppress. As a judge, I do not like on the day of trial when an attorney files a motion to suppress. On the day of trial, it is time to go to trial. You know, on that day, and except for exceptional circumstances, you want to really get your motions out of the way. In district court and circuit court, we have several pretrial diversion programs, and I'll quickly just go through those for you. Drug court, of course, is the largest pretrial diversion program we have, and that's the court that I presided over for about 10 years. The drug court program will take drug offenses if a defendant qualifies for the drug court program, and if you complete the program, then the case will be dismissed against you. We also have mental health court, veterans court, DUI, deferred prosecution. A new court that we have pretrial diversion program is theft court, and there also is domestic violence court, which I failed to put on the presentation, but we currently do have a domestic violence court. Jefferson County is very lucky in that we have lots of ways ways to dispose of cases by pretrial diversion, unlike a lot of other counties. But these are all pretrial diversion programs, and I would suggest you check with the judges about the judges of these specific courts to determine eligibility. Mental health court is run by Judge Stephen Wallace. Veterans court is run by Judge Michael Streety now. The DUI deferred prosecution program is run by Judge William Bell. And theft court is really just in the hands of all of us, so that if your client is eligible for theft court, then all judges will handle that. And drug court is run by Judge Maria Fortune. Theft court, I will encourage every attorney on this CLE, and also the prosecution. If a defendant has never been convicted, has no prior criminal history, and has picked up a theft charge, consider theft court. They will have to pay restitution, a couple of fees for the court referral program, and I don't want to just minimize it saying a couple of fees. There are some fees they will have to pay, and the case is dismissed. But the wonderful thing about pretrial diversion programs is that upon completion and at the right time, your client can apply for expungement. And attorneys, please encourage your clients to apply for expungement if they complete these programs. If your client completes drug court or veterans court and the case is dismissed against them, encourage them to apply for expungement at some later time. All right, the last thing I'll talk about before turning it over, and I know I'm kind of going fast, but I don't want to take up too much time, is courtroom etiquette from my perspective from a judge. Attorneys should always have on professional attire. Always. This is a profession. It is not a job. It is actually a profession. And too many times as a judge over the last 12 years, I've seen just unprofessional attire in court. A guy should always come into court with a jacket, a tie on, and a woman should come in with looking professional with the dress on. But there are, just make sure you look professional. I have seen in court where attorneys will come into court with things that are really nice for happy hour, after court, but they are not professional for court. And when you're in the criminal courthouse, you have defendants who have, lots of defendants who have probably not seen, a lot of skin in a long time. You want to cover up as much as possible. And so I would encourage you, just be professional. Be professional. Always, err on the side of being professional. And instruct your clients not to wear inappropriate clothing to court. And maybe one of the other attorneys will hit on this, but I would say the following are things that I've seen over the last 12 years. Shirts with naked women on them, marijuana, profanity, RIP shirts with people shooting up gang signs, house shoes, pajama shorts and pants, and hair bonnets. Those are all things that if someone comes into my courtroom, and instruct your client on this, if you come into my courtroom with pajamas on, I am not going to talk to you because I don't think you think enough of me to at least put on something to wear out of the house. I will never talk to a woman with a hair bonnet on in court. And tell your clients, don't expect for things to go well if you wear a shirt that has profanity on it in court. That is just a sign of disrespect. But those are some of the things that, that I've just observed. And I think it is important that you communicate that to your clients. As attorneys, don't lean on the bench. There are some attorneys over the years who will just kind of put their arm up on the bench and just kind of talk in a conversational manner. Unless you are invited to the bench for a private conversation, don't put your arm up on the bench. There are lots of times that you can talk to everyone in a conversational manner, and that can happen back in the judge's chambers, but respect the courtroom, respect the profession. Give your best effort in court and when communicating with the judge. I will always say this. When I was practicing in the DA's office, if I sent the judge an email, I wanted to make sure that, I had periods in the email, my sentences, were grammatically correct. One thing I'll say, I received an email from a judge who had, from a lawyer who had practiced for quite some time. There wasn't one period in that email. And I sent it back and said, I don't even know what you want. If you're asking me something, if you're telling me something, I don't know where to stop or where to begin. Resend this to me with some periods in it. I shouldn't have to tell a lawyer that. So give your best effort. I cannot reiterate, this is a profession that we are all so lucky to be a part of. It is not a job, it is a profession. And the last thing I'll tell you is to know your particular judge. All judges in courtrooms are different. Some courtrooms start at 8:30, some start at 9, some start at 9:30. Well, know your judge, because it works out better for you to build a rapport with the judge, and it works out better for your client. Know your judge. That is very important for your success in the courtroom. Okay, thank you. Turn your mic on, Holly.
Hello. What?
We can hear you now.
Okay, can you hear me now?
Yes.
Okay, let's see. How do I get back to Tiara's? There we go. Okay. My name is Holly Clemente. I am an assistant city attorney with the city of Birmingham. And before that, I practiced in the Jefferson County District Attorney's Office. So I have been a prosecutor for going on 6 years now. So I'm going to offer the perspective from the prosecutor. Okay, so I work at the Birmingham Municipal Court. There are 3 courtrooms. There are 6 judges that currently sit. Andre Sparks is the presiding judge, and we are located in the David J. Vann Municipal Center. Here's the address, the hours of operation. So in municipal court, unlike state court, we are authorized to hear misdemeanor criminal and traffic cases. So we hear DV third, assault third, trespass, DUIs, cases like that. And obviously, you know, we have the Birmingham Municipal Statute adopts all of the statutes included in 13A and 32, Code 32, which is the motor vehicle statute. So those are typically the cases that we handle. As Judge Owens was saying, we do in fact have the same kind of deferred prosecution programs. The DUI deferred, we have a domestic violence court, mental health court, theft court, and really depending on an individual's criminal history is going to determine whether or not they're going to be allowed in any of those programs. And we also cross-check. OPS has started something with the municipalities where we can go onto the OPS website and click and see if they've been in any programs in any other municipalities across the state of Alabama. So that's really helped us to exclude certain individuals from programs that they've been in 19 DUI programs. Well, at that time, no, it needs to go over to the county and they need to be prosecuted with more authority than we have at the Birmingham Municipal Court. You can change it. Okay, so the differences with municipal and state court, like I said, the main one is the types of cases that we handle. We handle misdemeanors and traffic cases, but most of the time, like I have actually been in court and I've recognized individuals that I prosecuted at the county. Actually, the first criminal trial that I had it was defendant Daryl Dixon. He walked into the Birmingham Municipal Court and was like, Holly, oh, great, nice to you. And so that was kind of a neat experience. But so if you practice in both places, you're going to see the same people. And the majority of our people have felony cases pending at the county. So I'm constantly calling over there saying, hey, what's the status of this? Look at this and that. If you have a client that has retained you on a municipal court case, please make sure you've got to verify if they have stuff at the county. You have to, because if you come into court and you don't know, I'm like, well, they have an aggravated stalking at the county in front of Judge Streety, and they're like, what? Don't do that. Come prepared. Know exactly what your client's situation is. There's nothing worse for a prosecutor than an unprepared defense attorney. Worst thing ever. And so that's one of the main things. In terms of the prosecutors and the judges in municipal court, you have to get to know them. The judges and the prosecutors in Birmingham are not going to be like the ones in Hoover or the ones in Vestavia or the ones in Mountain Brook. You have to know exactly what your audience is. And Judge Owens kind of touched on this. Every municipality, you have to think where it is, what county is it in, because municipalities in Shelby County are going to be drastically different than some of the municipalities in Jefferson County. So know your audience, get to know the prosecutors. We are not your enemy. If you're coming in, we want to work with you. We want to try to give you the discovery to say, hey, it looks like your client is guilty. Let's talk about what's the best deal that we can work out for your client. Or if, you really believe that, and sometimes the people are innocent. And I'm like, hey, so somebody else just admitted to this, so we're going to dismiss the charges against your client. So when you come in with that aggressive adversarial attitude, that normally is not going to work in your favor. And any defense attorney that's on here that's practiced with me in either Jefferson County or the Birmingham Municipal Court, they know exactly what I'm talking about. Go ahead. Okay, so the one big difference with the Birmingham Municipal Court, okay, so prior to 2018, you could serve discovery in open court on the prosecutor. And that was just kind of an accepted method of discovery. The new city attorney, Nicole King, who's my big boss, we were instructed to stop that. We're gonna follow the rule. So if you send discovery motions, they have to be served not on the municipal court, because the prosecutors work for the office of the city attorney, not the Birmingham Municipal Court. So you need to send it to the office of the city attorney, which is located at 710 20th Street North, and put it attention to Chief Ted Smith. He is the chief over the prosecution division. But then you also have to file it in with the municipal court. So it's kind of lots of steps. If you serve discovery on a prosecutor in open court, we are not going to respond to it. It has to be done per the rule. So just be mindful of that when you go to serve discovery in cases. And I would say the best thing, call and try to talk to the prosecutor, figure out who it is, or come up there and say, hey, let's have a conversation. They may not be able to talk to you if it's a really big docket, but reach out to them and try to form a relationship is really the main thing. Okay, help me help you. All right, so this kind of touches back to if you're a defense attorney, please be prepared. I know you probably won't have the incident and offense report. You'll get that from me, but talk with your client, try to figure out exactly what's going on, what's happening, what is the relationship between your client, the defendant, and if there's a victim, let's say your client has a DUI. Okay, do they have a drug and alcohol problem? You have to be prepared to give me that information when you come to court. I see that your client has had 6 DUIs over the last 20 years, but I don't know your client. You do, that's your job. Know them so you can convey to me, this person needs help. They don't need to go to jail. They need to go to help. They need to get help. And so that, be ready to advocate for your client. And I put the email of my legal assistant or the legal assistant for the legal department. If you need something, you can email the prosecutor, email the legal assistant, and now that we have gone paperless, and the transition happened in late 2018. So the Birmingham Municipal Court is completely paperless. There is a computer in the court specifically for defense attorneys. And not many people know that. It wasn't really advertised. I'm not sure why, but just ask. And this leads into the next stuff. If you don't know what packet to fill out, that the pink packet is for the DV court, if green packet is for theft court, yellow packet's for DUI, ask. Because you don't want to get through all that and then you come up and we can't accept it. So don't be shy. Don't be afraid, especially for the new lawyers. Just ask, because the prosecutors are in there every day. I mean, I'm in court every day except Tuesday. So we're going to be a little bit more familiar with what's happening in the Birmingham Municipal Court than you might be if you don't practice there all the time. So just ask. You can email me. You can look my email up on alabar.org and email me and ask, say, hey, can you send me this document? Do you have this? Do you have that? I will do it. I mean, it's 2 clicks from my computer. So, I'm always available to talk, whatever. Just form a relationship with the people if you practice in a municipality regularly.
Hello, everyone. My name is Tiara Hudson. I am one of the Deputy Public Defenders with the Jefferson County Public Defender's Office. Thank you both, Judge Owens and Holly, for your perspectives from where you sit. And everyone, I'm a defense attorney, a public defender, and so I want to give you some of my insights that I've learned over the past 15 or so years that I've been practicing. I started out in private practice, doing a little bit of everything, civil, criminal. Then I came here 6 years ago and been doing strictly criminal defense ever since. So I've had a lot of dealings with people on the civil side of things, the criminal defense side of things, and you really learn how to negotiate with people when you deal with so many people. So I want to talk to you all for a few minutes about the art of plea bargaining. And yes, it is an art. It is an art form. There are books about it. There are movies about it, TV shows. Not everybody has this gift, but it can be learned. You can learn it if you put your mind to it, okay? When you're negotiating in criminal cases, you're trying to work out a couple of different things. It might be about bond or the charges, trying to get a lesser included, or you're bargaining the facts, trying to keep certain things away from a judge or a jury. And most likely, definitely sentencing bargaining. How long is somebody going to be in prison? Or maybe they won't go to prison. Maybe we can work it out where they're on probation. So those are all the types of things that are covered when we talk about bargaining. Now, there are 4 parts to any plea bargain, okay? And my conversation is kind of dialed down a bit. I usually do a much bigger presentation that covers all 4 of these areas, but because of time constraints, we're really just going to talk about the second part about know your opponent, okay? Now, I'm going to preview my next slide. Before you talk about dealing with somebody else, dealing with Holly or any other prosecutor, you got to do some stuff with your own self first, okay? So I'm going to show you a quote, and I want to know if you all know this quote. You don't get to run, you're a gladiator. Gladiators don't run, they fight, they slay dragons, they wipe off the blood. They stitch up their wounds, and they live to fight another day. All right, y'all know who that is? Yes, Olivia Pope. This is what I've been doing during my quarantine period, okay? Catching up on Scandal. Mediocrity is not an option for us, okay? We are our clients' gladiators. You have got to get your mind right before you go into battle. You can't go and start talking to the DA and you don't know your client. You don't know what's going on. Or you just already decided in your mind, oh, this is a loser case. That is not how you gladiate for somebody. Another one of my favorite TV lawyers, and of course this is an all Black female panel, so all my quotes are gonna be about Black female, coming from Black females. So again, I'm not gonna try to hide in my corner trying to convince them that I'm friendly. I'm gonna kick them behind and remind them that I'm fierce, okay? And this is Jessica Pearson from a show called Suits. I still love it. It's not on the air anymore, but I love it. So when you go talking to the prosecutor, you got to know who you're dealing with. And this is one of my favorite TV lawyers, Harvey Specter, who's also on Suits. And one of his quotes was, I don't play the odds, I play the man or woman. So when you get ready to go into battle, first you got to prepare. You got to get your mind right. You got to know who you're dealing with and what is their perspective. So like Holly said, they are not the enemy, okay? We might have different goals in what we're trying to do, but they're humans, okay? They have a job to do, you have a job to do, everybody's got their job, so just accept that, okay? don't take it personal. Prosecutors, by definition, they are trying to seek a fair and just result as well, okay? And I know Holly's clapping, and you know, somebody might be out there saying, oh, this is just that public offender, public pretender talking, she just worked for the government anyway. No, I work for my clients. But if you think that it's all about just going at the prosecutor all hard, you are doing your clients a disservice, okay? You've got to know your own case backwards and forwards. Know your own case. The DA doesn't have all day to study your case. You have to tell them about your case, okay? Their office policies dictate offers. Once upon a time, copper was a big thing to go steal. And the DA's office, they had a policy about copper cases. They're not going to change their office. It was an office policy. It didn't come from the DA that you're dealing with. It came from somebody in the office that you probably never saw, and that is the policy. Deal with it, okay? And also you need to keep in mind that your victims influence offers. The DA has a lot of power. They don't have to listen to the victim ultimately, but a lot of times they do. They make a definite effort to contact the victim beforehand and say, well, hey, this is what we're thinking. Sometimes they don't listen because the victim is not realistic about, you know, I want life because they stole, you know, the air conditioner unit from my house. That's not realistic, but they do try to listen to their victims, okay? So how to handle the DA. And I'm not gonna tell y'all all my secrets, but these are just some tips, okay? You need to recognize that there are different cases, different personalities call for different strategies, okay? And it's a fine line between being, what's the word I'm trying to think of, just being slick and being genuine with people. I don't get to know Judge Owens just so I can get an in and try to win my case. I don't get to know Holly for that. People can read that, so don't be that person. Be genuine and just, I know Holly. I know what she does in court. And so I'm gonna respond accordingly to help my client because that's my ultimate goal. And I won't do the same things with Holly that I might have done with a different prosecutor. You just gotta know who you're dealing with. And if you're new to the courthouse and you don't know these people, that's okay. Sit back and watch. Pre-COVID, the courthouse was open and you could go watch and observe things. You learn a lot just by observing people, okay? Close your mouth and just observe. And then after you observe a little bit, go ask another lawyer, hey, have you ever dealt with this prosecutor before? And we share information on the defense bar all the time. Don't be afraid to ask. So when you're talking with the DA about your case, you need to share a little bit at a time. You don't put all your chips on the table, then you have nothing else to negotiate with because they know your whole case. Just share a little bit at a time. So I want my client that's charged with distribution of a controlled substance. My ultimate goal is to get them into drug treatment. Well, I'll start out. They need help. They were caught with drugs and they need help. Maybe that'll get me somewhere with them, but it's not quite what my client wants. So then a little later on, I might come back with another tidbit. Well, you know, the search warrant in this case, you know, some shady not right about it. I might break the DA down a little bit more and so on and so forth until hopefully you can get the type of deal or the resolution that you want, that your client wants in the case, but don't give it all up, okay? When you're talking to the DA and negotiating, just don't say, hey, I want a better deal. Then you know you have this staring contest. Tell them what you want. Give them options that are agreeable to your client. If you know your client wants to get out of jail and they have the means to be on electronic monitoring, suggest it. Don't just say, hey, you're gonna reduce my client's bond, you're gonna agree to a bond reduction, and don't give them something in return. That's easy. No sweat. Your client has the means to do it. Give it to them. And most important, don't usually accept the first offer made. Be ready with a counter offer. And you know I like TV shows and people think it's stupid. TV is fake. Look, it was based on some real life situation and some real life person. And usually there's some psychologist sitting on the staff of the TV show. There are some things to be learned about watching how people interact, okay, within the ethical requirements that we have, but there are some things to be learned when you want to negotiate with somebody. And these are some of those things. Now, what not to do? Say that your client, they're a good guy. So come on, Holly. They good. So what? They caught with, 2 kilos of cocaine. They're a good guy. You're not going to get anywhere with that. And they're going to look at you like you stupid. I'm being real with you. That you wanted a candid conversation. That's the title of the CLE, so that's what you're getting, okay? Don't come at your prosecutor with that, okay, and expect a good resolution. Do not negotiate with unrealistic expectations. If they are caught with two kilos of cocaine, there are some sentencing guidelines, some statutes that have mandatory requirements. You better come with something else, more like the search was bad. Something needs to be thrown out, but don't come with, just give them probation. It doesn't matter, it'll work. Don't tell the DA your client's life story. You need to pick and choose the points that matter to the person deciding. The DA actually has a lot of power. And Judge Owens told us this, the DA has sometimes more power than the judge. The DA is the one that can dismiss the case. The DA is the one that right out of the gate can reduce the charge to something else. Their minds don't have time to deal with, well, when they were 3, they just had a bad childhood. Tell them the stuff that matters and get to it quickly. Like we talked about, don't argue about the office policy, okay, where applicable. Sometimes, it's an outdated policy. That's one thing, but take that to the person who can change it. And that might not necessarily be the DA that you're dealing with, who's the line attorney for that courtroom, okay? And this might sound strange, this last one, but I've heard of it. I have never done it, but I've heard of it. Don't demand that the state drop charges or threaten to file a bar complaint against the DA when they are doing their job, okay? We don't make threats that you can't back up, okay? We don't like it when our clients do it to us, so don't do it to them just because they're doing their job. This is a long slide. It's rule 4.1. Don't lie. It breaks down your credibility, and people remember when you lie. The DA remembers when you lie. The judge remembers when you lie. The probation officer remembers when you lie for your client, and you will have no leg to stand on the next time you come back for the next client. So that's what I had to say about dealing with the DA. And I just want to touch briefly on dealing with the judge. Like Judge Owens said, you really need to know your judges, ask other attorneys, observe them. I've had judges that they hate clicking pens. Something so simple, they hate you clicking the pen in court, and it drives them crazy. Those little things, you just got to know about it, go observe and talk to people. But more on a serious point, dealing with the resolution of a case for your client. Sometimes you can't work it out with the DA. And the only thing you can, you know your client wants to resolve the case. For sure, they don't want to go to trial, but the DA just can't or won't give you what you need. Talk to the judge about doing a best interest plea, also called a blind plea or an Alfred plea, okay? Not every judge accepts them. What it is basically you're saying, Judge, the client is still saying they're not guilty, but they know that it is in their best interest to try to work out this deal, okay? And don't think that it doesn't show up on their background check as guilty. It still does. So it's kind of a technicality, but it does help a lot of clients get over that hump of just, I know I didn't do it. I'm innocent, but I know this is the best thing for me to do in taking this deal. And it's usually not accepted on Class A felonies from any judge, but it doesn't hurt to ask, right? Well, that was my insights. I think I went really quickly, I know, and I've seen the light blinking, so I think we got some questions. All right.
I want to say this, can everybody hear me? When Tiara just said realistic expectations when you're negotiating, that's also with the court. And I'm going to give you an example. If you ask the judge for a blind plea, if your client is charged with murder, don't start at probation. Don't start asking me, am I going to probate your client if he pleads to murder? Have realistic expectations. And an example of that, I had a defendant recently that was convicted of murder in my courtroom, and his attorney filed a sentencing memorandum, which I was very happy to get until I read it, because this attorney was asking me for a reverse split where a jury convicted, found him guilty of murder. And I believe the attorney had talked with the defendants so much about this reverse split that the defendant actually believed that he had a chance of getting it, because when I sentenced him to 35 years, he went bananas on me, as if he thought he was going to walk out of the courtroom with a reverse split. And so I say that to the defense attorneys: have realistic negotiation talks, even with the judge on a blind plea. Like, start somewhere that is realistic when you look at the charge.
And I will say, somebody asked about sharing a success story. And this story actually spans from my time at the DA's office to my now position at the city of Birmingham. There was a lady, Miss Webb. I was assigned to Judge Bill Cole's courtroom. We would see her probably once a month. It was prostitution, theft, just drug charges, everything. I mean, her life was just very, very bad. And so I had a candid conversation with her and said, you know, if we see you one more time, you were going to prison. It was me, her attorney, and Judge Cole. Unfortunately, we saw her again. And so she got sentenced to 3 years in prison. This was in 2016. Well, she got released in 2019. And so she got her life together. She got a job. She didn't start back using drugs. She walked into the Birmingham Municipal courtroom and I didn't recognize her. And so I see this woman that's crying coming up to me. So I'm like, and she was like, Holly? And I'm like, Chuck, it's me, Ethel Webb. She looked fantastic. I mean, it was night and day from when I saw her. So sometimes, you know, she got out and then she went through the program, and it changed her life. And she really said, she was like, you guys saved my life over there. So these programs are so valuable in helping people, especially veterans that, you know, have underlying issues that are related to wartime stuff. You know, sometimes, even as a prosecutor, sometimes jail and prison isn't the right thing. And you have to keep that in mind. It's what, like Tiara was saying, everybody's goal is to seek justice. And justice is not ship them off prison. No, that's not justice. It's not what's equitable. It's not what's fair. And so prosecutors especially, and I think for me, the longer I've been doing it, I think my perspective has changed a little bit. You have to realize that, you know, you look at humanity in and of itself, and that these are people and not case files. And I think when you do that, it will change your perspective on your offers and different things. So just, you know, like Tiara was saying, approach the prosecutor with realistic expectations. You know, somebody that's trafficking narcotics, hey, can he go into community corrections? No, come on, can't do that. So.
But I will say it's a fine line between completely unreasonable and just kind of being aggressive, being bold. But when you ask for that bold offer, don't get all in a huff because they say no. You tried. I'm not going to be mad at you for trying, and I don't think Hollywood either. But just don't get mad when they're like, nah, I don't think so today.
But I do agree with you. Come with options. Have a plan. Don't just say, well, what can we do? I don't know. What can we do? You know, have something in mind. And like, have a plan. Okay, if they say no to the diversion program, can I ask for this? Can I ask for that? Have a plan. You know, what is the saying about those who plan, failing to plan? It's something about failing to plan. Make a plan is the point of that. Okay.
That's the plan.
The exact phrase, but make a plan.
And I also want to say, don't forget about youthful offender status. Do not forget to apply your client for youthful offender status. You know, I can't tell you the number of times I'm on the bench and I see a defendant who looks 12. And I have to say, wait a minute, how old are you? What's your birthday? You know, simply ask your client their age, because if they were under the age of 21 at the time the offense was committed, they are eligible to apply for youthful offender status and apply every client for youthful offender if they are eligible. Don't say, well, we have such a great deal from the DA, I'm not going to do it. No, apply them for it, and the court can make a quick ruling on it, but it always needs to be on the record that the defendant, even on a capital murder charge, has applied for youthful offender status. So make sure you do that. And also, attorneys, remember, if the court grants youthful offender status, while I don't particularly like to have YO trials, your client has a right to have a YO trial. He or she does not have to plead guilty and you know, to the youthful offender. That is their right to have a YO trial. Now, I can think of, you know, better ways to spend my time than having YO trials on everything, but just to remember your rights. And in Jefferson County, I know I'm biased. I think we have a really good, you know, bench. But when you go to some of the other smaller counties, educate these judges, educate the prosecutors when you are there, you know, make them understand the rights that your clients have, because, you know, we are all looking for justice, as Tiara and Holly both said, and just educate the judge. And I know there are some things you're never going to be able to overcome in some of our smaller counties, but it is still your job to try very hard.
And I will say this, two things I want to say is about another success story with YO is I had a young man, he was charged with robbery. He wasn't the gunman that went in the convenience store. He was just the driver. And he was just hanging around some bad people. And so he had no idea what they were doing when they went into the store. He was just sitting in the car waiting on them to come out. And he got in this, you know, pattern of hanging around these people because his mother had recently died. And so he was just making bad decisions because he was really grieving. And so we managed to get him youthful offender status. You know, his record is sealed. We got him on probation. He did not have to do any jail time. And, you know, he has turned his life around. And years later, you know, he will still call me from time to time. This was probably 10 years ago now. From time to time, he will still call me. If he has a legal question about anything, you know, he'll call me. I left one law office and went somewhere else. He tracked me down where I went. It really matters to these people when you care. You know, your clients, they can see that you care. They can smell when you care. And they will, you know, respect you so much more just by knowing that you care and you are doing your best for them.
Tiara, you're definitely correct, because I think they feel when the judge cares. When I was in drug court, I have hundreds of success stories. I still keep in contact with so many of my drug court defendants. They come and see me, and I remember so much about them. Actually, 2 people that went through drug court under me are actually working in drug court right now. So pretrial diversion programs are amazing, and try your hardest to engage your clients in those programs.
And I totally agree with, and they remember the judges. I had a guy, I was with Judge Price, and I had a guy who told us that he was in drug court, and we were like, oh, with who? He was like, my girl, Shante Owens. Chuck was like, that's not your girl. He was like, no, she helped me. She changed my life. Chuck was like, she still ain't your girl. That Judge Owens, you know, but he really felt that you were his friend. And he was like, she really cared about me. So I think it really makes such an impact on people when the judges and their attorneys care about them. And I hate it when I see an attorney, a defense attorney, that either doesn't care or just, and I'm like, so then, and Judge Price and I have had this conversation with certain defense attorneys. Yeah, I'm like, I have to make sure that this person's rights aren't being violated. That every prosecutor has to do that at some point if their defense attorney is just not doing what they're supposed to be doing. And that's sad. That's sad.
And you know, again, I like TV and movie references. I'm not trying to be the attorney in the wheelchair like in the Tyler Perry movie, Diary of a Mad Black Woman. Like, I care. And if the minute I stop caring for real, you need to get out of this business because it's not for you. Are y'all typing questions in the chat, or you can unmute yourself if you have more questions? I think we have about 4 more minutes.
Ladies, I wanted to chime in. This is Chris Burrell. I wanted to chime in for a second. I really didn't want to necessarily say anything, but when we started talking about success stories, there was one I wanted to share. I won't go into any particulars. I won't share the gentleman's name because he has such an extraordinary story that I think that only he can tell it and do it justice. But I had a client 6 years ago who he didn't have anything major. It was primarily like traffic tickets and just like minor stuff in municipal court. But he was telling me that he really wanted to change. And, I started mentoring him. And ultimately, he kept saying that he wanted to go to law school. And I've had a bunch of clients tell me that in the past, but he was really serious about it. So I literally helped him get into law school. And he is graduating in the spring. And hopefully next year, he'll be joining us on the bar. And again, he'll get to tell his story at some point, but it's an extraordinary story. But I say all that not to toot my own horn, but to just let everybody know that's the impact that we can have in the careers that in what we do. As Judge Owens said, this is a profession. That's the level of impact that we can have. So I just wanted to kind of put that out there and let everybody know about that. And just always remember that that's the impact that we can have.
Amen.
That's awesome.
And I think Nina had a question about the biggest frustration in the field. For me, it is lazy lawyering, because I go back to this is a profession. I despise lazy lawyers. And maybe it's because I'm in the criminal courthouse and I know that what we handle, I mean, these issues are so very important to people. They're so important. And I just think if you're dealing with somebody's life and liberty, you should come in prepared. And I understand that there are some things that you don't always know, the victims nor the defendants always tell, they may not always tell you everything, the truth, about everything at once. But lazy lawyering, I despise. I don't care if your client is the worst person in the world. I feel like representation should be good on both sides. The prosecution and the defense should have good representation and let the system take care of it. But lazy lawyering, that's my biggest frustration. And sometimes one of the, I love our public defender's office now. And I'm going to say this, I love having a public defender's office because sometimes I felt in the past when we were just kind of handing out, cases, I felt as if sometimes people were just trying to, hey, this was just kind of something to just make a little extra money, but I don't know if they really cared. And even as a prosecutor, it mattered to me that the other side cared enough about their client.
Yes, don't be lazy. That's how I sleep at night. I mean, I don't think I can really sleep at night knowing, and there are times I'm in trial, I'm tired, but I will be up at 2 a.m. because I cannot sleep knowing that I have not done everything I possibly could for my client.
And I mentioned this
Judge,
to the ladies yesterday. Don't be the attorney who always needs a continuance. Like none of your clients are ready for anything. Like you're never ready for not one trial. Like and there are lawyers like that. Like they need a continuance for everything. Don't be that person. Please don't. I despise those people too.
and prosecutors, we despise those defense attorneys too.
Well, I think that's all the questions. Any final comments from anybody? Or questions? Chris, did you have anything else?
No, I don't have anything else. I just really want to thank you ladies for such a great job. I really enjoyed this one because obviously this is my area of law. So I've been probably as in tune to this CLE as I've been in any of them so far, but you all did a great job. I just want to thank everyone for joining today. And also, if you're not a member of the Magic City Bar already, please go to www.magiccitybarsociation.org and join today. Thank you.
Thank you.
Thank you.
Thank you.